We have two more motions. It's Mr. Vicente's motion, which is document number 80.
Dwight Vicente. Okay, on my motion about jurisdiction, I heard other people claiming political question. But for the United States, it's limited the power of Article 1, Section 8, which is Congress. Article 2, Section 2 is the President of the United States is limited to Article 1, Section 2, Clause 3, taxation and representation. They only cite 13 states. There's no amendment through Article 5 adding any new state into the Union. The confusion comes about with the Northwest Ordinance of 1787. Everybody referred to them as a Monroe Doctrine. Monroe did help write it in 1787. I call them the Three Stooges: Thomas Jefferson, James Monroe, and Dane, from a congressman from Massachusetts. They was trying to do exactly what they condemned the king of doing in the Declaration of Independence, and that goes back to the Continental Congress. They couldn't pay the soldiers. The soldiers had to bring their own gun and supply themselves. They were promised lands, to be given lands as compensation in the Ohio River Valley. And that's where you get the land claims from. And that's what the Northwest Ordinance is based on. And the lands is in Section 5 of that ordinance. I don't see the Hawaiian Kingdom or Crown and government lands in there. But for some reason, the United States has continued to wear two hats: Constitution under the 13 states, or over the 13 states, and the Northwest Ordinance of 1787 globally and beyond. They even took it into outer space right now, planted a flag on the moon, so they say. That might have been a conspiracy, though. So the history for this kingdom goes back to 1820. President Monroe sent Mr. Jones here to deal with this kingdom, Sandwich Isle Kingdom, without a treaty. Captain Jones in 1826 signed a treaty which under the U.S. Constitution is prohibited. Only the president with the consent of the Senate can sign the treaty. And it's very limited because Article 1, Section 8 limits the United States to 13 states only. They cannot extend them to any lands outside of the 13 states, which is what they did. That's a violation. And that's why the courts rarely get involved with any issue dealing with the Northwest Ordinance. Now I'm going to skip to 1875. The Reciprocity Treaty is based on that ordinance. If you read the Peacock case on page 40, well, it was 1887 amendment that they placed this kingdom under a protectorate status, and that's why the U.S. Navy was stationed here under the Northwest Ordinance rather than Article 1, Section 8, Clause 17. Needful buildings, arsenal, dockyards, it's in the 13 states, not outside. So they illegally occupied this kingdom, used it for target practice as far as the records show, 1893. When U.S. Minister Stevens came over to look at a volcano, there was lobbing rounds at Native Hawaiians. That's an act of war. That's war crimes. To scare the natives, they said. That's in Blunt's report. So you can see the history from 1887. The amendment of 1875 is a reciprocity, amended 1887. It was to go till 1894, the term. But there was stipulated in there that it would continue until either party discontinue it. And you're going to notice in the joint resolution of 1898, the Republic claiming the treaty was to continue beyond 1898, subject to the Congress terminating it. And Congress also agreed they're going to continue the treaty until terminated. And that's the 1898 joint resolution. But you see, all this is based on the Northwest Ordinance, not the U.S. Constitution. So when it comes to political question, 13 states is by themselves. Kingdom has its own political question between the crown and the legislature of the kingdom. So we have to get away from that political question dodgeball game they're playing. The courts have no jurisdiction over this kingdom. The Queen's protest of January 17, 1893 is against U.S. Minister Stevens. Article 3, Section 2, Clause 2 gives the U.S. Supreme Court original but limited jurisdiction only over U.S. Minister Stevens' illegal acts. That's the extent of the U.S. Constitution right there, or the court's jurisdiction. U.S. courts have never had jurisdiction. The case laws they're citing deals with the state of Hawaii, OHA, Hawaiian Homes. Hawaiian Homes is created in 1920 under the Northwest Ordinance, land claims. It goes by blood quantum, which you'll find in the Northwest Ordinance. Full blood, half blood. So you can see that they're trying to mix things, and the Indians in the U.S. Constitution, Article 1, Section 8, Clause 3, deals with commerce with the Indians in one of the 13 states. The Indians outside is not included because Article 4, Section 3, Clause 2 does not extend any of Article 1, Section 8 powers that Congress have to the Ohio River Valley. It's excluded. The only power they had was to dispose of and make all needful rules and regulation getting rid of those lands. They wasn't supposed to put their people in there to occupy and remove the Indians and set up a fake government. They're called 31 public land states. And you can read the book, The Old Northwest in American Revolution. They cite that, the history of the Northwest Ordinance. The Monroe Doctrine continues. So as far as for jurisdiction, the jurisdiction remained Hawaiian Kingdom because the United States still recognized by treaty, 1875 as amended in 1887, the Reciprocity Treaty. You cannot have a treaty with yourself. And that's why you're going to see the Joint Resolution of 1898, the Compact, Section 4 of the Admission Act. You only do that if they have jurisdiction over you. Here they don't have. They did the same with Micronesia. The Micronesians saying they have a treaty. The United States said, no, you have a compact. Compacts are reserved for the individual state under Article 1, Section 10, Clause 3, I believe. It binds only the individual state, not the whole 13 states. And a sovereign immunity thing under the 11th Amendment, there's no such thing. The United States is actually a corporation created by the people. There is no sovereign immunity mentioned in there. All it says in there, if you're going to sue, you have to sue all 13 states. That's all it says. You can't sue just one in a federal court. So the 13 is going to swing, not just one. So, and the other part was your disqualification. The treaties all ended with foreign nations in 1887 that King Kalakaua signed in 1897. It was signed in 1887. That includes Japan. The history of the Japanese here are they came over as contract slaves, 3 to 5 years, men only. Besides the Queen's protest of January 17, 1893, you have Japan filing a formal protest against the United States removal of the Queen. And they had later cut a deal with the military oligarchy to remove the protests, and they would be allowed to have the mail-order brides here. And that's how that's the history for the Japanese and Japanese only. As other people, they have their own history of why they're being here. But majority of the people here was contract slaves. They weren't here to stay. Even though the Hawaiian Kingdom had laws to naturalize, most choose not to. And the other part is that after World War II, General MacArthur signed the unconditional surrender in violation of the U.S. Constitution, and he also wrote Japan's Constitution, which places Japan under being occupied right now. In an occupied country, you cannot change your status. It doesn't matter who, Germans, Japanese, Native Hawaiians, anybody that belong to a country that is occupied. Now, by treaty, the United States has no authority to occupy a foreign country with the military. The military is restricted to the 13 states for the common defense. It has nothing to do with going out and conquering or anything like that. And the Northwest Ordinance should never be used. When they adopted the U.S. Constitution in 1791, that should have come to an end. But as you can see, the fake state of Hawaii was created, as Steinbeck stated in the 1950 Constitutional Convention in his first message. They're using the Northwest Ordinance. If you was Asian here, you couldn't be naturalized, not to mention all other foreigners. And there was applying taxes, which came not under Article 1, Section 8, Clause 1, but the taxing power came from the Northwest Ordinance, which violates the U.S. Constitution. So your qualifications is still, you're a Japanese national. It's a fact, unless you can disprove that by stating you're a national of the Hawaiian Kingdom. So you cannot be hearing any of these cases. And that goes for anybody who's not a native to this kingdom, native national, or has been naturalized as a foreigner to this kingdom. And like I always say, good luck. You're going to need it. Thank you.
I have no questions. So document number 80 has two parts. The motion to disqualify myself has already been decided by minute order number 14. The second part of the motion, challenging that the state of Hawaii lacks jurisdiction to hear this contested case, is denied. I will prepare the order for all the reasons that I have already indicated. Yes, Mr. Sinkin. I allowed you to speak to that already. We already dealt with minute order number 14.
I filed a response to Mr. Vicente's motion, okay? And the minute order that we're talking about, minute order 14, states that Mr. Vicente makes no specific argument as to disqualification of Judge Amano as hearing officer. So they acknowledged that his motion was not about disqualifying you because of who you are, where you came from, or how you got there. It's about the kingdom issues. And their order is all about the kingdom issues. It says nothing about you being disqualified. So I filed a response to that motion, and we're sort of in this catch-22. Was my response untimely because the board ruled on his motion, or was my response timely because it was before your deadline? This is what I was raising earlier, and I may not have been as clear as I should have been. So I wanted to clarify the record on that point. I'd also like to clarify the record on one other point. You stated that the status of the state of Hawaii will not be an issue in this contested case hearing. That conclusion assumes that there's never going to be any new evidence that was cause the courts to reconsider their view of the existence of the kingdom or its jurisdiction or any of the issues that have been discussed here today. So precedent has become set in stone, but that's not the way the law process works. Precedents can be overturned and reversed by new evidence and new argument. We're saying that we have presented new evidence and new argument that can be found in documents 126, 79, 132, and that evidence should be considered before any decision is made about the kingdom and whether it's relevant to this case. And finally, I would say that there's a solution to this, in my view, which is to invite the parties to brief the issue of the Hawaiian kingdom and its continued existence. And particularly, you can limit that, because of previous case law, you can limit that to a briefing on new evidence or new arguments never considered by a U.S. court or the United States executive branch, and see whether this new evidence might cause a different opinion as to the status of the kingdom. Thank you.
Okay, thank you, Mr. Sinkin. I stand by my ruling.